All right, guys. So we have a little bit of a breaking news, right? So in the evening, Cassie's lawyers, Douglas Wigdor in his office, his firm is the one that represented Cassie during the settlement civil lawsuit against Sean Combs. And so Cassie's lawyers have submitted basically a letter to the judge opposing of any unsealing of sexually explicit material of Cassie. And so let's get into what they wrote on this letter. Let me know what you guys think in the comments. Dear Judge, we write as counsel for Cassie Ventura in opposition to the news organization's applications for ordering unsealing sexually explicit videos that will be introduced into evidence at trial. Sealed video. EFC 327. And I believe we could probably find those on Pacer as far as like the codes that are sealed. The news organizations do not cite any case, and nor are we aware of any authority granting this unprecedented request in S trafficking case to unseal videos depicting coercive sex acts. For the reasons stated herein, we respectfully request that the court deny the motion and deny any request for news reporters to watch and listen to the video exhibits as they're being shown. So today there was some things, I guess, video that were shown, right? But it wasn't my understanding any sexual explicit material. It was really the 2016 CNN video, unless there was something else. But I mean, I'm pretty sure we were all in the same hearing and following everything. So the attorney cites the legal standard for sealing judicial documents. Federal courts employ two related but distinct presumptions in favor of public access to court proceedings and records: a strong form rooted in the First Amendment and a slightly weaker form based in federal common law. They cite there the case. In the analysis for either presumption, court must first determine whether the record is a judicial document. There is no dispute that the sealed videos, which the government will seek to admit as evidence at trial, are relevant to the performance of the judicial function and useful in the judicial process and are considered judicial documents. Because the First Amendment right is considered more stringent than the common law right of access, court needs not engage in the common law analysis when the First Amendment right attaches. So they have a footnote here in the letter. The news organization's position effectively seeks the unsealing of the videos as they're requesting public and media access to view the videos as they are presented to the jury. The jury's going to see videos of what looks to be freak-offs, and maybe videos of where Cassie was violated, or maybe videos where Cassie, participated. I guess it just depends. She might have been drugged. At least that's what the government is saying, right? But there's going to be videos that are going to be shown for the jury. Douglas Wigdor is basically saying to the judge, like, hey, the news doesn't need that. The news organization's position effectively seeks the unsealing of the videos as they are requesting public and media access to view the videos as they are presented to the jury. Their request that the court deny any motion to close the courtroom is premature and inept here, as there has been no such application made to the court, and it is understood that the sealed videos will only be accessible to the parties, the court and the jury. Okay. So it sounds like they're not really opposed to the jury watching them for the purposes of the court. They just don't want the news organizations to have them, which makes sense. I mean, honestly, I don't think, the news organization needs it, but hey, that's just my thought on that. That evidence may be relevant to the performance of the judicial function is not the only relevant consideration in evaluating the news organization request. In determining whether the public and press should receive First Amendment protection in their attempts to access certain judicial documents, the Second Circuit has articulated two approaches. Under the first test, the court must consider whether the documents have historically been open to the press and general public, and whether the public access plays a significant positive role in the functioning of a particular process in question. Under the second test, the court must evaluate the extent to which the judicial documents are derived from or are a necessary corollary of the capacity to attend the relevant proceedings. They cite a case here. In fact, this court previously affirmed that descriptions of the contents of the video at issue were appropriately sealed in the parties' submissions pursuant to, and then there's another case that's quoted here, in its addendum to Protective Order EFC 156, this court found good cause to order restrictions the parties have agreed to with respects to the storing, handling, and viewing of the sealed tapes, demonstrating that it intended for these videos to remain sealed during and after the trial. The court instructed Agnifilo LLP to return the devices containing the sealed videos to the government within a week following either the jury's verdict or the defendant's plea of guilty to the government, so that they can be destroyed in accordance with paragraph 12 of the protection order ECF 26. So basically demanding them for them to either, like, once this is over, turn them in so they can be destroyed. um I would imagine, okay, if you listen to the opening statements of the, state or the government, right? Um, this man was sitting on freak off tapes or tapes, okay, and using them as blackmail, collateral, that type of thing, right? Um, he was sitting on these for many, many years. He had plenty of time to destroy all that. He never did, y'all. So, if I was Cassie or any of the victims that are in these tapes, I would be very worried that Agnifilo or somebody in the team or, just anybody can leak things. I mean, guys, we saw somebody, what's his name? Israel Flores, who's an, LAPD officer now, right? He was making a copy of a video at CNN. Like, people see a celebrity and they get really creative about the things that they want to do and record. Okay. So you just never know. You never know. Let's keep going. The addendum includes specific language that the provisions shall not terminate at the conclusion of this criminal prosecution, and the court will retain jurisdiction to enforce this order following termination of the case. The court's prior ruling highlight a recognition that this particular evidence raises unique and compelling circumstances requiring a careful balance of interests. All right, B, highly sensitive exhibits implicated Miss Ventura's privacy interests. The presumptive right to access is outweighed by the privacy interests of Miss Ventura and others depicted on the videos. Documents may be sealed if specific. On the record, findings are made demonstrating that the closure is essential to preserve higher value and is narrowly tailored to serve that interest. The privacy interests of innocents and third parties should weigh heavily in a court balancing equation. Making the sexually explicit sealed videos public will effectively punish Ms. Ventura for testifying and re traumatize her, as the public will watch her abuse when she was at her most vulnerable. Oh my goodness. I would agree with that statement. Allowing the public to view the sealed videos would further violate her rights under the Crime Victims' Rights Act, CVRA, which affords her the right to be treated with fairness and respect for the victim's dignity and privacy. It would be profoundly unfair for Ms. Ventura's brave choice to testify publicly and using her own name to require such a gross invasion of her dignity. Yeah, this girl's been through enough, y'all. Like, honestly. Um, this is especially true because she will testify and be cross-examined about the contents of the video in an open courtroom, thereby undermining any arguments that the video themselves are necessary for the news organizations to report on the substance of this evidence. Ms. Ventura's privacy interest clearly outweighs the limited right of the public access in this circumstances. The news organizations do not cite any authority supporting public access to sexually explicit evidence shown to a jury in a sex trafficking criminal trial, particularly when, as noted above, the public will hear detailed testimony concerning the contents of the sealed videos. Indeed, case law cited by news organizations are an opposite and have facts entirely distinguishable from the unique circumstances of this case. So I'm thinking that the public news organizations are probably asking or wanting this stuff to be unsealed because it's for the jury it's a little bit different, right? Because they're having to watch this stuff. But I'm thinking for the news organizations, this is a whole different spiel, right? I don't no. Like, Listen, I don't, for her dignity's sake, for anybody, for the other Jane Doe, for any of the victims, nothing should be unsealed for any news organizations, honestly. Um, I think that the CNN video is enough. We don't need to see Cassie being violated or anything like that, or any kind of S act or anything like that, okay? Publicization of the unsealed videos will have chilling effects on other survivors. As the government has already explained in its opening statements in the case, unsealed videos depict individuals, including those other than Miss Ventura, nude, intoxicated, and engaging in S activities, okay? Public disclosure will jeopardize the identities of the individuals who are not testifying at this trial and may potential confidential pseudonymous witnesses. This is particularly so given that we anticipate Ms. Ventura will attest that defendant filmed her engaging in unwanted S acts and then threaten her with the distribution and publicization of these explicit videos to manipulate Ms. Ventura into doing what defendant wanted. Unsealing these videos would therefore essentially allow the media to carry out the very threats the defendant held over her head. I agree with this statement as well. Unsealing the videos would also therefore present an additional chilling effect on potential victims and witnesses who would be discouraged from cooperating with law enforcement and participating in the judicial process for fear of severe public humiliation and re-traumatization. The exhibits have minimal value to the public interest, to the public's understanding of the trial. The news organization's ability to report accurately and fully on this matter is not hindered by their ability to view the sealed videos, nor will the lack of access to the sealed videos obstruct the public's ability to monitor the judicial process and have knowledge as to the substance of the evidence. During her anticipated testimony, Ms. Ventura will describe the videos in detail in an open courtroom and will be subject to cross examination. The defense will be able to question Ms. Ventura on what the sealed videos depict, given the significance forthcoming testimony detailing the contents of the sealed videos and the news organization's acknowledgement that there may be significant privacy interests at stake. The media request that the videos are shown publicly is therefore unreasonably prurient. Okay, so then they quote, of course, a case here. Every court has supervisory power over its own records and files, and access has been denied where court files might have become a vehicle for improper purpose. For example, the common law right of inspection has bowed before the power of a court to ensure that its records are not used to gratify private spite or promotion public or promote public scandal. The public will learn of the content of the sealed videos through testimony in an open court without viewing extremely sensitive and sexually explicit videos, and all parties will have the opportunity to explore and probe the weight of this evidence, even with the reasonable guardrails the court has already placed around this evidence. For reasons articulated herein, we respectfully request the court deny the news organization's motions to unseal. We are prepared to address our position and any further questions the court may have during tomorrow's proceedings. We thank the court for its time and attention to this matter. Douglas H. Wigdor. Listen, I'm here for it. I'm so glad that Douglas Wigdor is, saying this. I personally don't feel like we need to see the evidence. I think that even reviewing what the witnesses are saying, even today, is enough. But I want to know what you guys think in the comments. Shout out to you guys for watching. Let me know. Do you feel like these not having access to these videos somehow, for the public to view is going to be a hindrance? I mean, what do you guys think? Personally, like I said, I stand with us not watching these videos. No news organization needs it. Guys, remember when this was reported? It was being said that there was going to be celebrities on these tapes. Okay. The only celebrity that we know of so far is Cassie. That's it. It was said that there was going to be minor children. No minor children. Of course, Cassie was 19 at the time that she was dating Diddy, okay, or dealing with him. Yes, but that's not a minor. She's 19, even though in my mind, I'm like, you're still a little girl because you're 19, of course. But still, like age-wise, legally, there's a different matter here. We're getting a bigger picture of what we have presently, guys. Let me know what you guys think in the comments. I'll see you guys on the next one. Rabbits out. Hit the like button and subscribe. Make sure you support the channel. I'll see you guys. Bye now.